All right, so we've got some craziness here. We've got Trump's Department of Justice arguing against guns in the Second Amendment, and we've got people who probably hate guns in the Second Amendment arguing for it. Yes, that's right. We've got Trump's DOJ using the gun grabbers playbook in court. We've got the anti-gun crowd probably using all the pro-gun stuff. What the heck is going on? Am I getting something wrong here? Is this opposite day? Let me know what you think, because we've got a crazy story going on in the First Circuit Court of Appeals, and there's big potential because we are talking about who does the Second Amendment apply to? Who are the people? The people. Guys, the people, you're going to be the jury on this one. Let me know what you think. Let's get into it. All right, jury. You are the jury viewers. Comment down below. Let me know if you think that Trump's DOJ is getting this right or wrong. Is Donald Trump's Department of Justice actually standing against the Second Amendment? In this case, it might look like it. The government is essentially arguing, and that's code for President Trump's DOJ, is essentially arguing that the Second Amendment isn't really for everyone in America. Rather, it's only for, quote, law-abiding citizens. You know that crowd? But here's the puzzle. Do constitutional rights hinge on whether you've ever broken a law? Is the Second Amendment, unlike other rights, some sort of conditional prize only granted to those with clean hands? That's what some are arguing. And if you think about this in yet more sarcastic terms, if rights really worked that way, then the moment that you broke the speed limit, or say jaywalked, or you filed your taxes late, could you lose the Bill of Rights? Just the whole package, the whole kit and caboodle. Just gone. Cruel and unusual punishment, open season. Right to silence, forget about it. Probable cause searches, well, hey, you jaywalked, you filed your taxes late, so tough luck. But for some reason, when it comes to guns, the DOJ here wants to carve out a special exception of sorts. And again, that's what some have argued. So the opening question in this case practically answers itself. Is the Second Amendment for people who are here, and guys, I'm not playing the politics game, illegal aliens, undocumented workers, foreign nationals here without paperwork, I don't care. Just pick an expression, okay? But for those folks, should they have the right to a Second Amendment? Or is it only for law-abiding American citizens? You notice how I set that up. Law-abiding American citizens. Who determines who is law-abiding? If you sped to work today in your car, does that mean that you can lose your Second Amendment? So you can see some of the doors and some of the gateways this could start to open. Not immediately in this case, but perhaps subsequently down the road. Now, the case exposes a very real tension. If the government is right, then the people in the Second Amendment, the rights of the people to keep and bear arms, right? The people. The people in the Second Amendment means perhaps only citizens, and maybe only citizens, moreover, who have never broken the law, wherever we are setting that line. Felonies, certain misdemeanors, whatever. If the defense is right, then the phrase means everyone physically present in the United States. And that interpretation might end up voiding the 1968 gun ban for undocumented immigrants, illegal aliens, whatever, throwing federal prosecutions into chaos. But it also puts the Second Amendment potentially into a strange category. You see, other rights like speech, your right to silence, your right to an attorney if you're criminally charged, don't suddenly vanish when you cross a border or commit some sort of crime. We don't say, sorry, you jaywalked, so the Fourth Amendment doesn't apply to you anymore. Or maybe more appropriately, sorry, you've been arrested for some sort of crime, but since you're not an American citizen, then you don't get an attorney. But somehow the DOJ wants to argue that point here, and that the Second Amendment stands apart, in a sense, contingent on the right that only belongs to good, law-abiding American citizens. Let's be clear, for those of you who don't know, undocumented immigrants, illegal immigrants, whatever you prefer, if you aren't a United States citizen in the United States, you don't have full rights. And I'm not trying to make that claim that you do. While you are entitled to due process under law, trial by jury, an attorney for you if you're facing criminal charges, you don't exactly have the same free speech rights. Why? Well, because if you speak out against the government, for instance, there's nothing really to protect you from being targeted for deportation. So there's always that backstop, there's always that check that the government has on you if you are here illegally, or frankly, even not illegally, subject to the visa and whatever else is going on. That all firmly falls into the bucket of it is what it is, whether you love it or if you hate it. So we've got a lawsuit going on in the First Circuit Court of Appeals. We're going to go through some of the, in my view, very interesting oral arguments with what little time we have left. We're going to start out with what the law is because so many people, including judges, get this wrong. June of 2022, United States Supreme Court issues the Brune decision. Before Brune, courts often balanced individual rights, and that's code for Second Amendment, against state interests in safety. And that's all code for you lose, okay? The win rate, if you go back, is about 3% for the Second Amendment. After Brune, that balancing test act, it's all gone. Instead, the government bears the burden of showing that a challenged gun restriction, gun law, regulations, so forth, has to line up with history and tradition. And we're talking 1700s to early to mid 1800s, okay? It has to line up with that tradition. If there's not a historical analog, if you cannot source a modern day, hey, we want to pass this particular law, and it's really close to that law back in the 1820s, if it actually is really close, and assuming that that is part of the historical tradition, nitpicking one municipality out of 13, 20, 30 states, something like that, isn't going to be good enough to get there. It has to be representative of the nation's tradition. If you can get there, you get there. That's what the status of the law is right now. However, that immediately creates a problem in this case because the United States had no real legal concept of illegal immigration until around 1875. At the founding, anyone who showed up was just present. So when the DOJ tried to argue history, it reached instead for examples of groups who were denied guns back then. The Justice Department argued that illegal immigrants aren't part of the political community. If you go through a lot of the Second Amendment case law, trying to get to the bottom of who are the people, you start to hear terms thrown around like the body politic, the political community, the people, and so forth. The DOJ pointed out that there were early laws between colonial and early America that did disarm Blacks, Native Americans, Catholics, as well as British royalists who refused to swear allegiance. The DOJ tries to use these examples to set up two different groups. You've got the in-group, white Protestants, and you've got the out-group, everyone else, or those basically distrusted by the political community who get no guns. And therefore, illegal aliens squarely fall inside that tradition because they're an out-group. It's in the words. Illegal immigrants, illegal aliens, undocumented, you name it. It's in the words. That's basically the gist of their argument. But the judges, they weren't buying it. One judge asked at oral arguments, quote, is a person here unlawfully categorically less loyal than someone here legally, but who has no intention of becoming a citizen? That question exposed the loyalty rationale as shaky. How many people have we all seen, whether in person or real life, who, born United States citizen, they don't have a single nice thing to say about Uncle Sam? I mean, it's kind of a fair point. Also, if you think about how many times the United States may compete against other sports teams, and it's a home event here, how many people who are United States citizens are cheering for the other team, regardless of who that might be? Mexico, Germany, England, France, I don't care. Pick a country. You can see how this starts to creep in. Legal allegiance versus actual primary allegiance. Interesting concept. Now, the defense argued that, look, there's no historical direct analog here. All those other things, too far, not close enough. Illegal immigration didn't exist really in the 18th century, so it's impossible for the government to find founding era relevant laws. Therefore, we win. But one, of course, the judges said, doesn't that actually hurt you if there's nothing that's analogous from that time period? Because after all, if the founding fathers didn't have to deal with an issue, then that means that issue is kind of preserved for a later generation to decide how are we going to treat this within our history and tradition. But I did like what the defense really argued here, talking about how these gun laws were really just nothing more than tools of subjugation. Disarming Blacks, Catholics, you name it, was about race, slavery, putting people down. It was not done out of neutral principle, public safety, or anything of the sort. This was not coming from that place. And disarming loyalists arose out of a context of war and rebellion, not a quiet community like the one in Maine that we're talking about here. So this case remains very active and ongoing. We've had the oral arguments. At some point down the line, we're going to be getting the written decision about what the First Circuit Court's going to be doing, and then it can go up to the United States Supreme Court, or not. Keep in mind, the US Supreme Court only accepts about 1 to 2% of cases that are appealed to it. So it's likely that the circuit court's decision will likely be it. Not necessarily because it's perfect, but because it is final. But this whole case is very strange to me because you've got conservatives arguing against guns. You've got liberals arguing for guns. Everything's mishmashed. Let me know what you think about this just spaghetti ball of problems down in the comment field below. Be sure to hit that like button. I'm really curious to hear your thoughts about this. Let's close out with our ever popular quote of the day. This one comes from Galileo Galilei, who said, quote, "Curiosity is the key to problem solving. Curiosity is what takes your brain places. Use it." I appreciate you in this one, and I'll see you in the next one. Take care. Thanks for sticking around to the end of the video. If you enjoyed this one, please feel free to check out some of our other great content, and we'll see you in the next one.